We know contract law allows for recovery under the theory of promissory estoppel, even without a contract, if an enforceable promise is broken. But what does that recovery look like? And how do courts handle damages for other claims arising from that same broken promise? The Seventh Circuit examines these very questions in the 1998 case of Cosgrove versus Bartolotta. When Joseph Bartolotta sought to open a restaurant in Milwaukee, he approached family friend and corporate attorney Barry Cosgrove for assistance. Specifically, he asked Cosgrove for a $100,000 loan and requested Cosgrove's legal and business advice for the venture. In exchange, Bartolotta promised to give Cosgrove a 19% interest in the new restaurant and vowed to repay the loan with interest over a period of 3 years. The two never did work out the exact terms that governed the 19% interest, and Bartolotta ultimately secured financing through a bank. Although his loan was no longer needed, Cosgrove proceeded to help Bartolotta with his lease negotiations, forming his corporate entity, and securing the bank loan. However, after everything was set up, Bartolotta never gave Cosgrove the 19% interest. Ultimately, the restaurant was a big success, and Cosgrove's potential 19% turned out to be valuable. Cosgrove sued Bartolotta in district court for promissory estoppel, misrepresentation, and unjust enrichment. The jury determined there was no contract for the 19% interest because the details hadn't been negotiated. However, it found that under a theory of promissory estoppel, Cosgrove was entitled to expectation damages for the value of such interest at $117,000 and also awarded Cosgrove reliance damages equaling $1,000 for misrepresentation and $17,000 for unjust enrichment. Upon Bartolotta's motion to amend the verdict, the court overturned the promissory estoppel verdict, finding that Cosgrove didn't establish reliance upon Bartolotta's promise. Both parties appealed.